Cover any of these topics in greater depth, please just let us know. So let's start with open meetings. This is the most important part that you need to know about open meetings, and that is the policy statement at the very beginning of the statute. Why is this important? Because if, by some unfortunate happenstance, you find yourself in front of a judge having to explain why you went into closed session or why you didn't notice a meeting, the very first thing the judge is going to read is right here. All meetings shall be publicly held to implement and ensure the public policy herein expressed. All meetings shall be publicly held in places reasonably accessible to members of the public and shall be open to all citizens at all times. And this provision is given liberal construction, meaning that when you show up to court, if you are a governmental official being scrutinized for having a closed session or not noticing a meeting properly, that deck is already stacked against you because there's a presumption that you should have done it properly, that you should not have been in closed session. So understand that the most important thing to remember in open meetings is check. Once you're sure, verify and double verify that you're doing things appropriately.
I have a question on that.
Yes, Ken.
Is it appropriate to go into closed session as the entire county board or as, say, the admin committee and singularly call in one after another department heads to get a feedback of the county administrator?
Is it appropriate under 19.85 1C, personnel evaluations are an appropriate reason for closed session? So the answer to that, just on those facts, is yes, that's appropriate. What I will tell you, leaning on the presentation from earlier today, that it's important to have a process, that if you're going to evaluate your administrator, one thing that you want to be sure of is that it's a fair and open process. And by open, I don't mean open to the public, but open in that everybody understands the ground rules.
Right.
So what I mean by that is, if you have an evaluation process for your administrator and you're going to weight 25% of the evaluation based on department head feedback, let your administrator know that.
Oh, certainly.
And then have a set of questions that you're going to be consistent in asking the department heads. But then when it comes time to meet with those department heads and get candid feedback, you can absolutely do that in closed session.
Okay, thank you.
All right, so what's the definition of a meeting? Everybody knows what a meeting is, right? It's pretty clear in the definition, and that's where everybody gets tripped up. Everybody gets tripped up on the definition of meeting. Right now, I've got 2 cases in my office where the allegation is there was a meeting, our defense is no, there was not. It's not clear. It's not entirely clear what a meeting is. So I will tell you what the basic law is. It's the Showers test. I refer to it as the 2 Ps for the definition of meeting. Remember people, remember purpose. It's called the Showers test, and I think I have it on the next slide, I hope.
PP.
If there are enough people there to have a meeting, and if the purpose of getting together is discuss governmental business, people and purpose, you've got a meeting. So is it a meeting when the county board gets together to watch the Packers in the Super Bowl in 2015?
No.
No. Is it a meeting if the supervisors get together to watch the Packers in the Super Bowl and start talking about the administrator's evaluation?
Yeah.
You bet it is. You bet it is. So again, when we get back to that whole concept from this morning about what you're going to talk about outside these walls, don't talk about county business outside these walls. You run into problems like this. And even if it was a chance gathering where a group of you just happened to get together at a particular tavern to watch the Super Bowl, if the topic of conversation shifts to county business, you might have a problem under the open meetings law. Because by law, you're required to post an agenda for that meeting. And by law, you're supposed to post that agenda at least 24 hours in advance of that meeting. So be aware, the Showers test, the 2 Ps, people and purpose, that's going to define when you have a meeting. When we talk about purpose, governmental business is defined very broadly. Any formal or informal action, including discussion, decision, or even information gathering on matters within your realm of authority. So even information gathering, even if you don't have a discussion, the fact of gathering information about a topic that's within your jurisdiction could trigger the open meetings law. We have the Badke case, which was the meeting within a meeting case, where the village board actually went to the plan commission meeting because the village board was ultimately going to consider the matter that was before the plan commission, and being good stewards and good governmental officials, they wanted to be there to hear all the information. The court said you had to notice that as a village council meeting, because you gathered information that was going to be weighed in your decision-making process as a council on the matter that the Plan Commission discussed. So understand, too, that it's not even necessarily your meeting. It may be somebody else's meeting, where if a quorum of you is present, you have to notice that as a meeting.
I have a question about that.
Yes?
What if you find yourself at a committee meeting and you have an item that is being referred to another committee, and you happen to notice that a majority of that committee is meeting or happens to be also in the room?
Yeah, and I mean, the easiest way to deal with that
Disclaimer.
is that at the bottom of every agenda, and this is what I recommend, and it becomes cumbersome and it sounds ridiculous, but just put at the bottom that a quorum of the county board or another committee of the county board may be present at this meeting, but no official action will be taken. That way you've noticed the public. At the same time you've noticed the public of that committee meeting, you've told them that a majority of this board or a majority of another committee may be present at that meeting, but you're not going to take any official action. Now, is that critical? Is it necessary? Is it required? I can't tell you for sure, but I can tell you that you won't get into trouble if you take that little step that way.
A follow-up, if you allow discussion from the audience on that particular item and members of the other committee are weighing in, is that crossing a line?
No, that's not crossing any
not
line. I mean,
voting.
they're members of the public, and they're entitled, as a member of the public, to exercise their First Amendment right to speak on certain matters, as long as the agenda provides for it. Now, the committee doesn't have to provide the opportunity for that other committee member to speak, just like the committee doesn't have to provide for a member of the public to speak. It's the open meetings law, not the public comment law, so there's no requirement that you allow the public to speak. The purpose of open meetings, remember, is for the public to monitor what's going on with the public's business, not necessarily speak about it. But if you have on your agenda an item public comment, I think best practice would be to allow anybody who wishes to speak, including any other county board member or committee member, to speak on that topic. Otherwise, you might run into a situation where their First Amendment rights could potentially be implicated. All right. On the number of members present, remember, it's not simply a quorum. There is a concept of negative quorum. For example, with a county budget, it requires a 2/3 vote to pass. That means 1/3 can block a budget. A negative quorum means the number of people sufficient to block any measure that could eventually come before the board or a committee. And so it's not simply a quorum or majority. Just remember, there is this concept of a negative quorum out there. Again, for purposes of determining whether you meet the first P requirement, people, number of people present. Technological advances, be aware of this. Telephone conferences, open meetings law applies to them. Can you have a committee meeting by telephone conference as long as your local rules allow for it? Absolutely you can. You just have to give the public an opportunity to monitor that telephone conference. So what you do is you have a committee meeting by telephone conference, and then you have in the clerk's office or some other conference room here in the administration building, is you have a speakerphone there that the public can listen to the committee's deliberations and the committee's discussion. Do they have the right to speak? No, absolutely not. But they have the opportunity to listen, and on your agenda you say, listening device will be made available for the public at this room, at this location. If you need, if you have accommodation requests, please contact this number, and then you're good. Then that complies with the open meetings requirement. Where we see a lot of the issues come in is in dealing with electronic mail. The Attorney General has issued a series of opinions out there about how electronic mail presents certain dangers under the open meetings law because of the reply to all, forward features that are contained on email, so a private communication between two supervisors, neither of which would constitute a quorum of any committee or the board itself. All of a sudden, the message that was transmitted between two gets disseminated out to 7, gets redisseminated out to 12. Pretty soon, you got yourselves a quorum, or at least a negative quorum, and they're all receiving the same message at the same time, which the Attorney General has said, that's a meeting. And so be very aware that when you're dealing with electronic communications, that may trigger certain open meetings requirements. Walking quorums, we talked about this a bit this morning, but again, a walking quorum, a series of gatherings among separate groups of members of a governmental body, each less than a quorum and a quorum size, who agree, and this is important, tacitly or explicitly. Either agree by action, by nod of the head, by wink, by understanding, or actually expressly agree. So it doesn't have, you don't have to show that there was an actual meeting of the minds and an agreement. It is that the Attorney General has said that a walking quorum issue arises even if you've got tacit agreement among the group. Problems with walking quorums, predetermined outcome, we talked about this briefly before. Petitions and walking quorums, if you sign on to a document that a subject be placed on an agenda. In other words, I want this on the agenda for the next meeting. That's not a walking quorum issue. That's asking that it be put on the agenda. The agenda will be posted, public notice given, and you discuss everything in a validly noticed meeting. However, if you have a petition where you take a particular position on a topic that's about to come before the board or a committee, you could have a walking quorum and an open meetings violation issue there. And so be very careful about signing off on petitions that deal with actual substance versus putting something on the agenda. Remember that only the board or a committee, the governmental body, has a power to close a meeting, that the public cannot demand that it be closed. In very limited circumstances, under 1985-1B, an employee can demand a closed session on a matter that's the subject of a quasi-judicial hearing where evidence is going to be taken and the committee or the board acts as the decision maker. Then an employee can demand that it be held in open session but cannot demand that it be held in closed session. So remember, only a governmental body has the ability to close a meeting. Who may attend closed sessions? We get this question quite a bit, and the advice I always give is only allow people into that closed session who have a need to know the information. If they don't have a need to know the information, there's no purpose for them being in the closed session, and in many ways, that just obliterates the need or the actual justification for a closed session. And think about it again. If you're going before a judge, and judge says, hey, why'd you let Bob into this meeting? Bob didn't do anything in this meeting. Well, I like Bob. I wanted Bob to hear that information. Well, what is that telling the judge? Is that you're selectively picking and choosing members of the public to be in that meeting, and the judge is going to say, well, why did you close the meeting? There was no purpose of having a closed session. So again, people who have a need to know belong in that closed session. Yes, sir?
Well, suppose Bob's wife wants to attend with him.
You have the right as a governmental body to determine who can stay and who goes in that closed session. The only limitation on that is under 19.89, I believe it is. Grant, correct me if I'm wrong. You cannot kick somebody from this board out of a closed session meeting of a committee unless you have a local rule allowing the committee to kick somebody on this board out. And so that's the only limitation. Otherwise, with everybody else, the committee itself determines who stays and who goes. But if Bob's wife wants to stay, I'm telling you right now, she better have a really good reason for staying in that closed session. Because even if Bob's necessary and Bob stays, that doesn't mean Bob gets to bring his wife and daughters into the conversation as well. That's a concern of mine. Yes?
I think I misunderstood what you just said. If a subcommittee has a closed session, they cannot kick out another member of the county board?
Correct.
That is not part of that subcommittee?
Correct. And the way that the statute reads is you've got parent body, in this case it would be county board. You have sub-body, which is committee or subcommittee, all right? Sub-body cannot kick a member of parent body out of the closed session absent a rule authorizing sub-body to kick that person out. So if you have a rule on the books that says we get to kick you out, you can kick them out, all right? But if you don't have that rule, statute says they can stay for that closed session.
Do they have to ask, or, I mean, it's automatic?
As a matter of common courtesy, I think they could ask.
We do
but-
have a local rule that excludes any members, any board members who aren't a member of the subunit, but they can ask the chairperson to remain in the
It is
room.
written.
And that rule is perfectly consistent with statute.
So you can ask. Be told no.
All right, there's an open meetings compliance guide that I ask that you go home and bookmark on the internet, because that compliance guide is very lengthy, but it addresses each and every issue that could ever come up under the open meetings law. I can't tell you the number of cases I've had on open meetings throughout the years, but each and every instance, on every case I've had, the topic at least was addressed in that compliance guide. The Attorney General is the chief watchdog for open meetings issues, so the Attorney General is responsible for interpreting the law and providing guidance on the law. Does that mean the Attorney General is the judge? No. Does that mean that every single court out there is going to agree with the Attorney General's interpretation? No. But courts give the Attorney General's interpretation a lot of weight and a lot of deference. So make sure you understand where that compliance guide is. Yes?
I have been told that it's very hard to prove open meetings violations. Has that been your experience?
It's very hard to prove. I think it depends on the circumstances, and I will tell you that the litigation is lengthy and painful enough to act as a deterrence, so that even if you get into it and say, well, you're never going to be able to prove this, by the time you get done showing that you're never able to prove this, it's a lot of money that didn't have to be spent. So I'd say there's a deterrent out there, because the aspect of this is that there's personal liability on you as board members for an open meetings violation. How do you avoid that personal liability? You act on the advice of counsel, all right? So if your corporation counsel says, yes, you can go into closed session, that doesn't negate an open meetings violation, but it does negate personal responsibility for you. But the other feature of the open meetings law is that somebody who sues you for a violation of open meetings gets attorney fees if they prevail. And so you're not only paying for your lawyer to handle the case, you're potentially also paying for the other side's lawyer to handle the case. And I've seen those numbers get really, really big. All right, so just be aware of that. There are deterrents out there to avoid, even though a claim may seem to have no merit whatsoever, pay attention to that stuff. It's very important and can be very costly for the county. So let's talk briefly about public records law. Very similar to open meetings law in terms of the policy of the state. It's declared to be the public policy of the state that all persons are entitled to the greatest possible information regarding the affairs of government and the official acts of those officers and employees who represent them. Again, you're going into court, standing before a judge on a public records violation issue, and the judge immediately turns to this, and he or she starts with the presumption, again, that deck is stacked against you. Everybody's entitled to this information. You have to prove out that you're innocent. Entirely different than our criminal justice system, where you're presumed innocent until proven guilty. Here, you're presumed guilty until you're proven innocent. So understand that. Again, providing information on the affairs of government, presumption of complete public access consistent with the conduct of governmental interest. General, except as otherwise provided by law, again, talking about that presumption, talking about that deck being stacked against you. Any requester has a right to inspect any record unless there's a specific exemption applying. So what is a record? The area where the public often gets tripped up on this is that there's a distinction between what we have in Wisconsin as a public records law and what federal officials deal with as FOIA or Freedom of Information Act requests. We don't have a public information law. We have a public records law. And so the public has no right to come in, ask a question, and demand an answer under the public records law. The public has a right to come in and demand a record, and if we have that record, we provide that record. But you'll see one of the features of the public records law is that we're not required to compile a record in order to respond to a record request. We are required to give access to records that are responsive to a requester's request. So understand that if anybody gets into the distinction between the Freedom of Information Act and our public records law, that is a big distinction. Electronic records, information regarding government business, email sent or received on an authority's computer system is a record. So I often get this question, especially from county board members. I have a Yahoo mail address or a Gmail address. Is that subject to public records? You bet it is. If it's connected to your office as a county board member, you bet that's subject to a public records request. And so what I always say is a best practice is to route all official email communications on anything having to do with county business through the county's IT system. Because I've seen it the other way, where we are chasing around on personal email accounts for copies of old emails. Heaven forbid they be deleted. Heaven forbid we can't access them, because that gets really ugly under the public records law. But if everything is routed through the county's IT system, then we have an IT staff who is very capable of going through, running the appropriate searches, and ensuring that we've got the right response for that public records request. I don't know, do you do that here, Grant, with the IT system?
Right. We have any emails that come across the county system is automatically retained for 7 years, and we have the ability to put a litigation hold on them. So I've preached that we have to go through the county system. I know sometimes that doesn't happen.
The safest route is if you get anything on a personal email that's in any way connected to your official function, forward it to your address, your official address here at Door County. And that way it's on the system here. Mark?
When we rolled out the Zooms 3 years ago, everybody got a county email address and was told that that's the way they do business, and now
Good.
they're all being archived, so.
Good.
And to some extent, almost, I guess, more important than the public records is the evidentiary presumption. If you've done nothing wrong and somebody makes an allegation that Grant sent me an email on August 11th, 2010 that said XYZ, and you said, yeah, I sent that email, but I can't find it, but it didn't say that, there's a presumption in some cases that it says what the person, I can't remember what the presumption
It's a
is.
spoliation rule.
Yeah.
And if you get into the spoliation rule, there can be sanctions imposed for destroying evidence. So, very important. What's not a record? The statute defines what a record is not. Drafts, notes, preliminary documents, similar materials prepared for your personal use or by the originator in the name of a person for whom the originator is working. I often get this question too. What about minutes from a closed session? You're all asleep still. There are no minutes from a closed
I was just
session.
gonna-
That was a trick question. There should be no minutes from a closed session. Are you going to have notes from a closed session? Maybe. Are those notes from a closed session a public record?
No.
Hopefully not, unless you take those notes, copy them, and send them out to 5 people you think might be interested in the contents. Then it might be a public record, but your personal notes are not going to be a public record. But are those personal notes subject to discovery on a lawsuit that's filed challenging, for example, your hiring practices? Absolutely, it's discoverable, all right? So maintain them. They may not be subject to a public records request, but maintain them anyways. And if you ever have a question about that, like if it is a hiring decision, you're making notes, ranking people, or whatever the case may be, best practice, route them through the Corporation Counsel's office, so Corporation Counsel can tell you either how to retain them or retain them himself.
Question.
Yes, sir.
Right now, the county board members all have Zooms, tablets. The next revision might be where the county board members get to choose and purchase their own personal piece of equipment. At this time, I'm still personally against that. I believe in trying my best to keep them two separate. How is that sitting right now in the state as far as treating the personal equipment that I'm using to access my county email address, everything else that's going on there? So how is that opening up personal equipment and then in turn opening up personal accounts relative to the open records law?
Well, and that's where you get into some details on, the records law says that you're entitled as a requester to the data in its original format. And so the original format would be the electronic information that is stored on the device that created the record. And so in that instance, would the public have a right to demand that they be allowed to inspect your computer or your tablet to get the document in its original format? It's never been extended that far in a case that I'm aware of, but that theory is out there, which again, in my mind, counsels heavily in favor of having specific county property creating the official county record or the official county public records. That would be my inclination. It's not been carried that far in terms of opening up your personal tablet for inspection, but again, the records law says you're entitled to get the record in its, origin format.
So in theory, using my smartphone to respond to a constituent's email could open up my smartphone and its activities to the open records law.
In theory, but I would also, if I were representing you in the county on that case, I would say, look, here's what the email says, you've got a printed copy. That's just as good as the original electronic format, and only if they could prove, I would think, some sort of reason as to why they needed the original format versus the paper copy, would they be able to prevail on that. But again, that's not a case that's been tested to the best of my knowledge. Another area that comes up in is if you send text messages on your personal phone to a department head, how long do you retain those text messages? Well, a data service isn't going to retain those text messages very long, so in many times, once you've sent it, it's gone. There's no way you can recreate it. And what do we do about that? Because by law, those text messages, they're a public record. Again, that's the danger of using some of these technological devices to create public records without the adequate tracking and backing of your IT department.
So a general rule of thumb would be to try to stay with a corporate issued piece of equipment for your daily activities.
Absolutely, absolutely.
Well, Andy, there was that case in the city of Madison where the city council met till, was it 4 o'clock in the morning, and they were texting back and forth to other council members, and the newspaper requested those records. There was like 7,500 records that they had to make public. It was all on their smartphones. They were texting back and forth during the meeting.
I guess the follow-up on that would be, where does that bring the ability for a requester to look for more information on that personal piece of equipment? Not necessarily, in evidence trying to find backing up that text that they're referring to.
Well, they'd submit another request, and then you have an obligation to respond to that request, and that request may lead to another request, and so it becomes a series of requests. So where does that stop? It doesn't stop anywhere, because they can keep submitting a request each and every day if that's what they want to do. It becomes challenging. Again, what's not a record? Purely personal property of the custodian with no relation to his or her office. Personal email sent on an authority's computer system is a record. Understand we had the Schill case that came out about 2-3 years ago, and in that Schill case, it was a Wisconsin Rapids high school teachers that were sending emails to their spouses and friends. Purely personal in character, went all the way to the Supreme Court. Supreme Court didn't reach a majority decision, they reached a plurality decision, which simply means they couldn't agree on any one aspect of the opinion, but all of them agreed that, hey, you know what, on purely personal emails of that character, even though it was created on the authority's computer system, that's not subject to a public records request. The Attorney General has construed that very narrowly, and the Attorney General has said, hey, as long as it's created on county property, that's going to be a public record, except in the most exceptional of circumstances. Denying a request, you have to be very specific in your denial or partial denial of that request. Again, you can take a look at a lot of these cases and statutes that talk about how the denial is put together, and also understand that in many ways it's kind of a rock and a hard place analysis, because you have an obligation to respond to a records request. At the same time, in responding to that records request, you may be implicating various other constitutional or statutory rights for these individuals, some of whom may have a right to privacy. So if somebody requests a record and that record contains somebody's social security number, you have an obligation to redact that social security number, and if you don't, the person about whom that record is could sue you for saying, hey, you violated my privacy rights by disclosing my social security number, and then the person who made the request may say, yeah, but you have an obligation to respond to me in full. So just, it's the rock and the hard place. Be very careful about the information that you're providing. It's not just responding to a records request. It may also implicate certain constitutional or statutory rights. Analyzing the request, again, start with the presumption of access, very strong presumption. Then records custodians go through this balancing test. And essentially, the easiest way to describe the balancing test is saying, all right, over here you've got the public's interest in disclosure of records that deal with governmental affairs. And here you've got the government's interest in ensuring that private affairs stay private. So which one's heavier? And that's the balancing test. And whichever one wins out, you have to analyze that, and then you have to write down in that letter exactly how you went through the balancing test, how you reached the conclusion you did, and you either redact in full or you redact in part the information or the record that's provided back to the requester. What does this tell you? Is that this is some complicated stuff. So make sure you consult with your corporation counsel when you're going through this process. That's critically important. Whether it's an open meetings issue or a public records issue, when in doubt, always call your corporation counsel. There's nothing more dangerous than you receiving a request from media for all your email communications and you just give them a data dump of all your email communications. That's incredibly dangerous. Various rights are implicated, so be very careful about that. We have in this presentation, which will again be made available to you, the steps that you follow in responding to a records request. Does the record exist? Is the requester entitled to access the record by statute or by court decision? Step 3, is the requester prohibited from accessing the record by statute or court decision? And then step 4, does the balancing test compel access to the record? So you go through all 4 of those steps in determining whether to grant access to a particular record. Again, there's an enforcement mechanism right within the statute. And just like under the open meetings law, this statute has a fee-shifting provision, meaning that somebody who represents a records requester gets paid, that attorney gets paid by the governmental entity if they're successful on their challenge under the public records law. So you're not only paying your attorney to defend you, you're also potentially paying the other side to prosecute you. Again, that can get very expensive, and it acts as a very good deterrent on complying with the public records law. We have individual penalties as well. Forfeiture and punitive damages may be awarded in certain circumstances. Again, those are rare, but it's not unheard of. I've seen them before out there. There's no penalty under the law for disclosing a document that may have been exempt from disclosure. Again, unless there are individual rights that are implicated by disclosure of that record, you're not going to get into problems by over-complying with the public records law. Again, we have some things to remember in here, and that bottom, get advice from legal counsel or Department of Justice, just like with the open meetings law. They have a public records compliance guide. The Attorney General is the chief watchdog in the state on public records issues. He produces a compliance guide which goes into detail on each and every topic that I've discussed here and each and every topic under the public records law. I encourage you again to bookmark this site on your home computer. That way you can find out each and every small minutia detail about everything within the public records law. So let's talk briefly about ethics and the smell test. Ethics for local government officials and employees is codified in section 19.59 of the Wisconsin statutes, and there are categories of things that are banned under those statutes. First is ban on use of public position to obtain financial gain or anything of substantial value for the benefit of you, your immediate family, or an organization with which you are associated. And now that's clear as mud, right? Because everybody knows what anything of substantial value means, right? Some people, it might be a $5 cocktail. Other people will say, that doesn't mean anything to me. And so, again, the statute uses somewhat vague terms. We've got some guidance from the Attorney General. We've got some guidance from the Government Accountability Board about what some of these terms mean. But again, I want you to view this not necessarily as a black or white issue, but a gray issue. All right? So when you look at a particular circumstance, at a particular set of facts, you think, okay, does this smell in the least? And if it smells in the least, go and talk with your corporation counsel and find out, do I have an ethics issue here? And what is the public's perception of this particular issue? Because it may come down to where, hey, you know what? Anything of substantial value means more than one of those giveaway erasers that my kid gets at the school fairs. But if it looks bad that you took that eraser, you may not want to take the eraser, even though it's not an ethics violation. So use these guidelines as issue spotting to define, again, that gray area where further guidance is needed. It's also under 1959, there's a ban on offering or giving directly or indirectly. So it doesn't have to be direct, it can be indirect. Anything of value to a local public official if it could be reasonably expected to influence the local public official's vote, actions, or judgment, or could be considered a reward for action or inaction. And so again, the statute uses some of those vague terms. Reasonably expected to influence. What does that mean? That's a tough one. Again, we're defining the gray area where whenever we have this situation arise, when you need to go talk to your corporation counsel and get some guidance and advice. Ban on taking any official action substantially affecting a matter in which you, a member of your immediate family, or an organization with which you're associated has a substantial financial interest. I didn't talk about this before, but let's talk for a moment about member of your immediate family. Spouse is included as member of your immediate family. Child is included only if your child receives 50% or more of his or her support from you, or conversely, if you receive 50% or more of your support from somebody else, that person is considered a member of your immediate family. So when we talk about, I saw this happen in the context of, out in the western part of the state, they've been dealing with a lot of frac sand mining issues. And you wouldn't believe the amount of actions that were taken by town boards, county boards out there and things like that, and the newspaper articles that were out there. And there was one particular case where the town board chair was taking action on the rezoning of a parcel to allow frac sand mining. Well, that parcel was owned by the town board chair's son. And everybody just had a fit because that was an ethics situation. This guy ought to be brought up on charges. Well, son's 40 years old. Son was living on his own. He'd been emancipated for 22 years. And so there wasn't an ethics issue. But did that smell? Oh, it smelled to high heaven. So should the town board chair have done something to avoid that smell? You bet he should have. So again, that's just highlighting the difference between what the law considers to be an ethics issue and what the public considers to be an ethics issue. And I think it's incumbent on you to hopefully avoid both of those. You may participate in an action even though technically it may be a conflict of interest if it's what I refer to as a class action. So, for example, let's say your spouse works in the highway department. And let's say that the highway department collective bargaining agreement comes before the county board for ratification. Can you vote on that collective bargaining agreement, because that CBA contains a wage rate, contains benefit provisions, contains things like that. I'm talking about pre-2013 for Door County. Can you vote on that? Yeah, absolutely you can, because your spouse is just one of many whom this particular action affects. So the law says, because you're dealing with a class of people who are all similarly situated, you can vote on that. But what does the public think? Does it pass the public's smell test? Is it something that you ought to think about recusing yourself from? The law says you can do it. But again, think about that gray area and think about the public's perception and what is in the best interest of avoiding that smell entirely, all right? Ban on use of your position in a way that produces or assists in the production of a substantial benefit. Again, we use the term substantial benefit, direct or indirect. I have no idea what that means, honestly, because it's in the eye of the beholder. For you, one of your family members, or an organization with which you're associated. State statutes don't prohibit you from taking action on salaries, benefits, or reimbursements, or from voting on an ordinance. So that's one of the exceptions under the Ethics Code. Intentional violations, there are penalties, not less than $100 nor more than $5,000, or imprisonment of not more than 1 year in the county jail, or both, so you can get fined and get thrown in jail. Political contributions in exchange for official actions, that's a felony. Not in this presentation, but 946.13 is the conflict of interest statute. If you engage in conduct that is a conflict of interest under 946.13, if you're found liable, it is a felony, and so be very aware of 946.13. The interesting thing about any of this is that it doesn't require intent as an element. In other words, the prosecution doesn't have to show that you intended to violate the statute. All the prosecution has to show is that all of the elements of the statute are met without regard to intent, all right? So again, be very, very careful when dealing with these ethics and conflicts of interest situations. Unintentional violations, civil penalties may be imposed $1,000 for each violation. Other legal and equitable relief, and then the bottom point, reasonable cost may be awarded to the plaintiff or the state if the plaintiff prevails. So again, just like with open meetings, just like with public records, you may be paying two attorneys on the case, the one on your side and the one on the other side if they prevail. So you avoid liability through your get out of jail free card, and that card is available for your use at your corporation counsel's office. Use it judiciously. Use it a lot. If you've got this issue, it's in the back of your mind, go to corporation counsel, and if the issue is high profile enough, ask the corporation counsel to commit the opinion in writing. That way you have that backing to know that you're doing okay. Now, that doesn't mean that every single day you inundate corporation counsel with written opinion requests. There ought to be, again, a policy on how you go about doing that, and in under what circumstances will corporation counsel put an opinion like that in writing. But if you have the opinion from corporation counsel, you're entitled to rely on that opinion, and you're not going to be held personally responsible as long as you follow the advice given by corporation counsel in that opinion. I don't know if there's anything you wanted to add on that, Grant.
And ask for the opinion before you act, because my policy is I will not offer an opinion after you've done something. Because
That's right. That's kind of like when somebody sends a contract for my review. They say, will you review this contract? What difference does it make? You already signed it. Yeah. I'll review it and tell you what it says, but it makes no difference at this point. Next time, send me the contract before you sign it, and I'll give you a little further guidance. So Grant's absolutely right. So then we have the questions to ask yourself, the smell test. And these 6 questions that I've put here right in the presentation are the ones that are going to hopefully generate in the back of your mind the need for further guidance or the need to avoid a situation. Am I, my immediate family or organization with whom I'm associated, receiving anything of value for private benefit because of the position you hold? Am I using the influence of my position to solicit something? Am I or my immediate family or an organization receiving anything of value that you've not paid for? When official action on my part possibly result in private benefit to me, my immediate family or organization with which I'm associated, will the use of my staff or the staff of the county or employees of the county or the public facilities of the county or the equipment of the county benefit you in a private capacity? Am I using public time, public employee time, departmental time, resources, facilities, equipment, anything like that for your own personal gain? or for the personal gain of an organization with which you're affiliated. If you answer yes to any of those, that's where you go to Corporation Counsel. And that's where I see a lot of problems coming up, is that people say, well, it's not a big deal. The highway guys are right here outside my house. I'm donating this couch to the church. The church is on the way back to town. It's only a 2-block detour to deliver this couch. So I asked the guys, hey, can you drop this couch off, please, on your way home? Is that all right? Again, nobody's making any money off of this. Nobody's doing anything that seems absolutely bad. But is that something that triggers the smell test? You bet it is. You bet it is. Go get an opinion from Corporation Counsel on that, or better yet, don't do it. Just avoid it altogether, all right? So with that, I'm sorry I've taken so long here. Finally, Mike's on board. He's been itching to talk here, and he yelled at me at lunch saying that I was talking too long.
Can I ask
So
a question
finally-
about the smell test? real
Sure, absolutely.
So me and another supervisor go out for dinner with our wives, and I say, I'll pick up the tab.
No, that's fine. You and another supervisor. That's not, I mean, if it's you and a, we run into problems there. Let's say that it's a department head that
No, no,
goes
no,
out
no,
with
no,
you
no.
and decides to buy you dinner.
Yeah.
Is that a smell test
Let me
issue?
rephrase that then. Let's say that me and 3 other supervisors go out for dinner, and I pick up the tab as well.
Unless they show that it's in exchange for...
Not that I'm going to do that, but I was just,
I was going to say, you've got people raising their hands saying, I want to go out to dinner with Don. I don't think that's a smell test issue unless you're paying for their dinner in exchange for their vote on a topic. But I just don't see that as a better issue is like a department head, though. Let's say you and 3 supervisors go out and decide to have the department head buy you guys dinner. That's a problem.
I understand
That's
that
fine.
part.
Grant.
You might want to mention, and you know better than I, with the government, GAB set the bar pretty low with the door prizes. What was something about
$25. $25.
It doesn't take much to get you in trouble.
No. So that means that if you see, for example, an attorney and WCA's chief of staff at the conference and want to buy them a drink, you can do that. We cannot buy you a drink, though. I always like to say, though, if I could get all the county business in the state by just going around and buying people cocktails, I would just go on the road with my checkbook. That's not going to happen. So I don't see any issue with if we're all standing around at a bar, if I buy you a beer or you buy me a beer, that's not going to do it. As soon as we start getting into the lobster dinner and things like that, that's where we got problems.
You're fine until they start videoing with their phone.
That's right. That's right. Other questions before I turn it over to Mike? Yes, sir.
What about contributing to a campaign, like senator, or helping with the campaign?
There are election laws that govern state officials that are different than election laws that govern the local officials. So there's a ban on offering any political contribution in exchange for official action. There's no prohibition other in the ethics code, the local government ethics code, on anybody like a state senator contributing to your campaign or vice versa. However, there are limits and regulations that apply to both of those campaigns.
So I could contribute to a campaign?
Yes. Yes. Within the rules, yes. Mhm.
Is there not something in the law that you should have a written document as to how somebody would acquire public records? That they came to the window, that you should provide them written, here's the form?
There is something in the law that says you have to have a policy on how somebody requests public records. Absolutely. Yes, that's in there. And that's not a topic I covered today. Again, I was talking at very high levels. There's a lot of stuff in public records law that I didn't cover. That's covered absolutely in the compliance guide about what that policy has to look like. All right. Mike?
Sure. Jill? County clerk, yeah.
And next, back.
Thank you.
Thank you very much, Andy. Again, my name is Mike Blaska, the Chief of Staff for the Wisconsin Counties Association. Actually, Andy, I kind of hinted giving up the chair, but it felt good to be back in the seat again after all these years. I'm going to talk about running effective meetings. I think it's very important that everybody have a kind of a basic understanding on how to run a meeting. Obviously, we're all at a meeting. We need to know how to behave here. But you as leaders in your community serve, I know a number of you serve on town boards, you might be on village boards, city councils, even civic organizations, athletic type boards. People look to you as leaders in the community. Can I do this? Can I not? So I think it's important to have a basic understanding. A lot of what I talk about, in fact, everything I talk about are issues that have come up over the years that I've been on the board and the 10 years now that I've been with the Counties Association, questions that have come from county supervisors. And the other thing I want to point out is that a lot of what I talk about you might not be doing. That doesn't mean you're doing it wrong. Whatever works, works. And if you're doing it and it's worked, that's fine. But what I'm going to talk about is things that you can do to make your meetings more efficient, more effective, and more professional. So where do we get our rules? Well, we get some of our rules from state statutes. State statutes tell us when we're going to approve the budget, it takes a majority vote. But if you're going to amend the budget during the year, it tells us it takes a supermajority, a 2/3 vote. You have your local rules. You have your own rules and that you adopt. A lot of them, our counties adopt their rules as part of their policy. A lot of them incorporate them into their county ordinance. And of course, there's always Robert's Rules of Order. It's really unwise for any assembly or society to function without some formally adopted rules of order. And for many organizations, that manual is Robert's Rules of Order. So, and the latest edition, it's Robert's Rules of Order, newly revised 11th edition. And I usually bring that with me, I forgot. It's kind of a thick book. That's why it's good to have your own rules. A lot of counties incorporate some of the major rules in Roberts into their own local ordinances. So it's easier, more accessible. I'm also going to talk about rules of decorum. So when I talk about parliamentary procedure, it's not all about motions. Do we need a second? Is it debatable? Does it require a 2/3 vote? But also, Roberts talks about how we behave, things we should do and should not do at meetings. So one of the first things we're going to talk about is avoiding the use of members' names. Now, I've been to a lot of county boards where they refer to each other by their first name. Yeah, Mike, what did you think about that? Jane, back and forth. Robert suggests that we should avoid doing that because sometimes you're going to get into some heated debate. It gets very personal when you call each other by your first name. The better approach is to refer to each other as Supervisor City, Supervisor Schultz, Supervisor O'Connor. Or you refer to them as the previous speaker said this, or the supervisor from District 3, or the chair of the Finance Committee. There's always a way to refer to each other than by their first name. And it's the same with the chair. The chair doesn't speak in first person, he speaks in the third person. The chair feels, the chair rules, the chair is of the opinion. So there's always a better way to do it. And as I said, I've been to a lot of county board meetings where they're referring to each other by their first name. Doesn't mean it's wrong, but again, it can get personal. And when the public is looking in, they say, gee, it looks like a good old boys club there. They're calling each other by their first name. It just makes the whole proceedings more professional. Member never speaks while seated. Actually, in your board, you do speak when seated. That is absolutely fine. And that's another example where Robert suggests one thing, but you can have your own rules. Robert says that the motion to adjourn is non-debatable. I know in our county, Dane County, it was debatable. That's the way they wanted it. So that's fine to be seated. That's the way your systems work here with your microphones. But nonetheless, before you speak, you have to address the chair and obtain the floor. A member has not obtained the floor until he's been recognized by the chair. So you can't just start speaking. The chair has to call on you. And it varies in counties. Some have an electronic system where you push a button. Otherwise, you stand, raise your hand, somehow get the chair's attention. You'll always address all your remarks through the chair, not the body, not the gallery, or not the TV cameras. I've seen several situations where they're televising the county board proceedings and supervisors will get up and every time they speak, they look directly into the camera. They're talking to the public out there. No, you're always addressing the chair. I've seen in the larger boards where a person sitting up in front might actually turn and face the body. Feels like they're speaking to the body, always address the chair. But in situations where you may have a big crowd, because you have a public hearing, and so they turn to address the crowd. The gallery might be on the side, so they face the gallery. No, you always address your remarks through the chair. And even if you have questions of other supervisors, you don't just ask the supervisor, you ask the chair. Mr. Chair, I have a question of Supervisor City. Then the chair will call on that supervisor and ask if he wants to respond. Andy talked a little bit about some of these things. All persons meeting have an obligation to obey the presiding officer. Members using parliamentary forms for obstructive purposes should not be recognized or ruled out of order. The chair's job to enforce the rules relating to debate, order, and decorum, and remind members to confine the remarks to the merits of the question. Very important. And all these things that I'm talking about is not just what I feel or folks at the UW Extension or Andy Phillips. Every bit of all these statements are directly out of Robert's Rules of Order. The chair announces issues, keeps members on track, restates the motion to place the before the body and for clarity. Also very important, so sometimes you'll have people yelling out motions. First of all, as we said, you have to get the chair's attention. You have to have the floor. The chair recognizes you, makes a motion, waits for a second, and then restates the motion to place it before the body so everybody understands what the motion is. The chair asks for votes on each side and announces the outcome and responds to questions and rules on points of order. Members' remarks must be germane to the question before the assembly. That's come up in a lot of board meetings. In one particular county, they were concerned about the administrator. They'd hired a new administrator. They weren't happy. They went from administrative coordinator to administrator. Chair said, they keep bringing it up all the time. And that happened over a year ago. Well, why do you allow them? They should be speaking to the question before us. The comments must be germane to the question before you. Speaker must address their remarks to the chair, maintain a courteous tone, avoid injecting a personal tone into the debate. Member has a right to speak twice in the same question, can speak no longer than 10 minutes in total. A lot of boards don't follow that, and again, that's fine. But what this rule does is forces you to think about what you're going to say. It forces you to plan your debate. So every time a supervisor gets up, you want to comment on that. Another supervisor gives you a comment. This forces you to think about it a little bit and kind of prepare your remarks. Presiding officer should relinquish the chair if entering the discussion. So can the chair participate in debate? Yeah, absolutely. It's one of the members of the board. However, the chair is considered to be impartial. His job is to run the meeting, to be fair to everyone. Now, if the chair wants to speak, he must get off the podium, join the crowd, and let the vice chair or second vice chair run the meeting. And the chair should not resume as the presiding officer until that issue has been resolved. Of course, in small boards and committees, the chair can speak as often as he or she wants. We were just in Portage County last week. Portage County has a rule that the presiding officer may debate from the chair's position, and that's fine. As I said, you can always adopt your own rules. Business is brought by a motion by a member. A motion is a formal proposal to take action. The basic form of motion, the only one that brings business before the assembly is the main motion. So we're going to talk a little bit later about other motions, but it's the main motion that brings the business before the assembly. Member must obtain the floor when no other question is pending and when the business of the kind represented by the motion is in order. Member must obtain the floor before making a motion or speaking in debate, and a motion is not before the body until stated by the chair. Again, we talked about that. You get the floor, you make a motion, we have a second. Now the chair restates that motion to place it before the body. Sometimes, as we said, really you can't speak on the board floor unless there's a motion before us. But sometimes you may need to give a little explanation as to what you're going to do because you may not be able to get a second. So it's all right to preface by a few words of explanation. And sometimes you may need some help in assisting the member in framing the motion. So maybe you know what you want to do, so you ask the chair, and the chair may get some help from the corp counsel as to actually how to frame the motion. That's certainly permissible. Yes?
Sometimes it's hard to get a second when you have a motion made, and we've used, I'll second for the sake of discussion. Is that considered valid then?
Sure, absolutely. Absolutely. That's fine. And so, as I said, that sometimes you may want to give a little explanation as why you're doing it in order to get that second. That's what this talks about. But yeah, lots of times, maybe you're not for it necessarily, but I'm okay to have some discussion, so I'll second it. Maker of the motion may not withdraw the motion once stated by the chair as a property of the body. Lots of times you may have a motion, you start debating it, you realize this is a really bad motion, we shouldn't even be discussing it. Can a member, the maker of the motion, withdraw it? Well, not really, because it's not that person's motion to withdraw. Once it's been made and seconded, it's been restated by the chair, the motion belongs to all of you. No one person can withdraw. However, if everybody agrees that it's a really bad motion and we just soon see this go away, the chair can state, without objection, hearing no objection, the motion is withdrawn. So you can do a lot of things by consensus. It's without technically making the motion to suspend the rules. That's actually what you're doing when you do things by consensus. Discussion of any question is permitted only with a reference to a pending question. Until the matter is brought before the assembly in the form of a motion, it cannot be debated. The general rule against discussion without a motion is one of parliamentary procedure's most powerful tools for keeping business on track. Again, you have a motion, we're debating it, it makes your meetings more efficient, more effective, more productive. Presiding officer must never interrupt because he knows more about the matter than the speaker. Sometimes we'll see that, where the chairman will say, well, your statistics are wrong. It's not the chair's job to point that out. If the chair wants to come down and speak in debate, it can do that. Or if he wants to call on a department head to address the body, he can do that, but should never interrupt. Maker of the motion may vote against it if he's not allowed to speak against his own motion, and you must avoid personalities and under no circumstances question the motives of another member. And he pointed out when I was on the town board, there's nothing that stirs up the people more than a rezoning petition for a mineral extraction site and a conditional use permit for a blacktop plant. Gravel pits and blacktop plants, that stirs up the people. I was supporting the petition, and another member said, well, the reason Blaska is for it is because his brother owns a trucking company. Well, that was totally inappropriate. He's questioning my motives. What we should be speaking to, is it a good idea to have this mineral extraction site, or is it a bad idea? Is it okay for the environment? Are we providing the safeguards? Not questioning my motives. Now, if this actually is a rather serious charge, and if he thinks that I have a conflict, then he should contact me directly or call the district attorney. But again, you never question the motives of another member. Andy, usually you have some smart comment here?
No, I'm
no,
good.
That's good. That's,
I'm not too smart today.
Member who makes the motion is entitled to be recognized, so now if you're going to have discussion, the person that made the motion is entitled to speak first. If no one is entitled to, entitled to a floor a second time, if a member has not spoken, desires the floor. So if at all possible, you should get everybody a chance to speak once before you allow another person to speak a second time. We talked about this earlier. No member can speak more than twice, no more than 10 minutes in total. It's actually in Robert's rules in different places. And somebody said to me, gee, that's not very often, 2 times 10 minutes. We've got a budget as a major document. That's on every motion. So the main motion, according to Robert's rules, 2 times 10 minutes. Now we have an amendment to amend the budget. It's another motion. So you got 2 times 10 minutes. Now I have another amendment, same thing. We've got a motion to postpone. Again, 2 times 10 minutes. And for those of you that like watching C-SPAN, you cannot yield your unused time. Rather obvious, refrain from disturbing the assembly. If at some point during the meeting you really want to talk to another supervisor, got something going on, just ask for a short recess. Robert suggests that you should not read from or have the secretary read from any paper or book as part of your speech without permission of the assembly. Members are permitted to read short, pertinent, printed extracts and debate as long as they do not abuse the privilege. So at some point, maybe you do want to read something, some short excerpt. That's fine. The best way to do that is, Mr. Chair, if there's no objection, I would like to read this short paragraph. Member who rose and addressed the chair first after the floor was yielded is entitled to be recognized. Exceptions to the maker, those who have not spoken in opposing opinions should alternate if possible. That's actually pretty hard to do. However, if you have a public hearing, it's wise to have people register for and against at the public hearing. But you should alternate in those cases back and forth, because if I'm the chair and we've got a zoning petition before us and I'm in favor of it, what am I going to do? I'll have all the opposition speak first, and then all those in favor speak last, because that's the last thing I want you to hear, because I'm for it. That's why you should alternate back and forth.
I have a question.
Yes, sir.
Can anybody tell the chair not to read something himself or herself?
You can always raise a point of order, and I'm going to get into that in a second. So, Committee of the Whole, one of the reasons I have this slide in is that we had, in one of the counties, the county board chair had what he called a couple of rogue supervisors, in that they were having their own meetings. They weren't happy with what the county board chair was doing, the direction he was going. And so what they did is convene, they actually called their own county board meeting. They gave the date, time, place, and the subject matter. They posted it where all the county board meetings are posted. They notified the press, said the subject matter, and they even said on there that there may be a quorum of the county board. Now, the board chair said that's an illegal meeting. You think it's an illegal meeting? No. Somebody said, no, of course not, because they gave notice. That's exactly what we talked about earlier. You have to give notice. You can't do it in secret. You can't go to the bar in the back room and talk about it. You give notice. The public's invited. The press was invited. But what I told, and the chair was just totally convinced that there was an illegal meeting. I said, what you should do is convene the committee of the whole. What these supervisors wanted to have is just open general discussion without being bound by having to have a motion, limited to debate. Just have an open general discussion. So the committee of the whole is a tool that the counties could use. We see it used a lot in city councils, but not so much at the county level. So you have to convene as the county board, and then you go into a committee of the whole. So maybe it's a huge matter that rather than send it to 1 or 2 or 3 committees, you just meet as a committee of the whole to discuss the matter. Content of minutes, purpose of this slide is not necessarily to tell you what should be in the minutes. The point here is that they should contain mainly a record as what was done in a meeting and not what was said by members. This comes up a lot where someone will make a statement and say, and I want that recorded in the minutes. We used to have a person on our WCA board of directors that they did that often, and he said, I want that recorded in the minutes. Well, I took the minutes and I didn't record it. But in fact, we just got a call, it was 3 weeks ago, where first of all, it's a very difficult thing to do, because you'd have to have a stenographer taking down everything that was said, or you'd have to have a tape, and then you'd have to go back and listen to the tape. 3 weeks ago, we got a call where a supervisor made a statement. They put it in the minutes. The supervisor did not like when she saw it in print, the way, what it said, and denied saying that. Well, they said they went and listened to the tape, and that's exactly what she did say, and so they're wondering what to do. She said she didn't. I said, take it out, because it's not important what was said, it's what was done at the meeting. Now, you can have some, in the minutes, say that, you know, the county board talked about building a new hiking trail, but not specifically what individuals said. So I'm going to talk I got a couple slides on some motions and misconceptions. Motion to lay on the table. Roberts even states that the motion to lay on the table is probably the most misused of all motions. The motion to lay on the table should be ruled out of order if the intent is not to take the matter up later in the meeting. So we're in the middle of the debate. We need more information. The Corp Counsel has to go back up to the office to get the information. Do you sit and wait? You could, or you lay it on the table, because you're going to take it up later when he gets back. Or maybe you need information from the administrator. Maybe it's 2 o'clock. We've got the public hearing scheduled. We'll lay this matter on the table and take it back up after the public hearing. A lot of folks use this motion to postpone or to kill a matter. That is improper. The reason being is that the motion to lay on the table is non-debatable, where a motion to postpone is debatable. So by allowing this motion to proceed, if the intent is not to take it up, you're depriving the body of the right to debate. Motion to postpone must be to a time specific. So the motion to postpone alone is also out of order. It must be a time specific. So I postpone until the next meeting. I postpone until after the Finance Committee is acted. I postpone until after July 1st. Must be to a time specific. Motion to postpone indefinitely. This is a motion you can use when you really don't want to vote yes or no on a particular item. You realize it's an item that probably shouldn't have even come to the county board. That I talked about earlier. If somebody wanted to withdraw the motion, somebody objected, then move to indefinitely postpone. This does kill it. It is debatable. It's also a nice tool. I like using it. Maybe you had a matter before you, say you had a zoning petition. I'm against the zoning petition, but I have an amendment to make it better. But I don't want to make it better because I'm against it. And I don't know where the votes are. So I may make a motion to indefinitely postpone. That kills it. If it passes, I win, I'm happy. If it doesn't, now I can see where the votes are and say, oh boy, it looks like this is going to pass. Now maybe I'll make my amendment to make it better. Moving to the previous question, this comes up a lot as well. So what does it mean when somebody calls for the question? And a lot of societies, they take it to mean we've had enough debate, let's vote. And I've seen it where somebody calls for the question, they say, why are we still debating this? I called for the question. No one person can cut off debate. If their intent is to move the previous question, which is a technical term, that does cut off debate and needs a second. It's non-debatable and requires a 2/3 vote. The point to remember is calling for the question really means nothing unless you're actually moving the previous question. And if it's interpreted to mean that, then fine, get a second, non-debatable, takes a 2/3 vote. Point of order, this gets to your question. If you feel that some rules are being violated, we talked a lot about the chair's responsibilities, but it's also your responsibility. If you feel that the rules are not being followed, if somebody is questioning a member's motives, if the speaker's comments are not germane to the question before us, raise a point of order. You can just yell it out. You don't have to get the floor. Point of order, Mr. Chair. Chair then will call on you and ask you to state your point of order, and then the chair will rule. And sometimes it's not a point of order, so you have to be very, very careful about that, that you're actually calling in to question a violation of a rule. And again, we talked about you have to be careful not to abuse that privilege, but again, you do have that power. And you can always appeal the ruling of the chair. A lot of get calls and from county board members saying, the board chair is a tyrant. We know that's not the case here. But the chair has a tremendous amount of power and authority when it comes to running the meeting, but you can always appeal the ruling. So you make a point of order, the chair maybe doesn't agree, you can then, and he makes a decision, you can appeal that decision to the body. It does take a second. All the members can debate at once. The chair can speak as often as he or she wants from the podium, and a simple majority can then overrule the chair. So if we follow all these great rules, then we'll avoid this kind of activity. I was actually watching the 10 o'clock news one night when I saw this live, and they were just throwing punches and slugging each other. We want to avoid this situation. So if there's any questions, we field a lot of questions, so feel free to call our office. Obviously, you can always talk to your corp counsel, but we're also available to respond to any questions. Any questions? Any questions at all? Oh, I did have a handout on running effective meetings. The other thing I wanted to point out is we actually distributed a card that I think came with the county officials handbook. It's a little smaller version of this, but just to explain this handout, basic information on motions. So it talks about ranking motions on the left-hand side. This is kind of a nice guide for you. You'll notice it starts with 13, 12, 11, 10, 9, down to 1. So what's 1? 1 is the main motion. That's what brings business before the assembly. What this is telling us is that whatever motion we're at, all the ones above it are in order, the ones below it are not. So we've got a main motion before us. Now somebody makes a motion, say like number 8, to lay on the table. Somebody else wants to make a motion to amend. Is that in order? No, because that's below that. Only the ones above it. If somebody wanted to make a motion to adjourn, they could do that. But before they can make a motion to amend, we must dispose of the motion that's on the table right now, which is to lay on the table. Once that's disposed of, then you can go back to your motion to amend. Any questions? Not, thank you very much. And Andy and I appreciate the opportunity to come up and address your county board. We kind of gave you a full, almost a full load, didn't we? It's a lot of information, but as I said, we're happy to come back. And one of the things that the association that our board of directors directed us to do is to do more outreach. So if you ever have another meeting where you have some slow time and you want us to come in and specifically address any one of these issues, we're happy to do that. If you want us to come in and do a legislative update, we're happy to do that, or even if it's to a committee, talk about the state budget and where we're at, we enjoy doing that. Some questions, that's all.
Yeah, I just wanted to thank you for doing an outstanding job on your presentation. It was very informative.
Very good. Thank you.
Thank you. Question over here.
I have a question on clarification that came up after Andy was giving us the what for as far as what authority the committee has, and we can cite the highway committee, asking the highway commissioner to go for an RFP for equipment. It's budgeted, and then it comes back to the highway committee, and he recommends what should be purchased. Does the committee then still have the authority to either agree or disagree with the recommendation?
Well, it depends on your policy. If you have a policy that the committee has final approval, then that's your policy, that's what you do. There's no law on this.
Okay,
There's no law on this. And
I'm
so-
getting all kinds of information right here from the highway committee.
Okay.
What was your?
I do believe we have that policy, that we will review the commissioner's recommendation.
Okay.
Right?
Ken, is that what you had?
The highway committee has a policy in place.
I don't know if you have a policy, I know we always do that.
And even the next three
We will have one
resolutions
next month.
that are coming up require certain purchases of the highway department to come to county board, even though some have been appropriated in the budget, and they came about 20 years ago.
Yeah, any expenditures over 100,000. Okay.
Okay, if not, again, thank you very much for having us.
Okay, thank you.
Yeah, I don't want to hear that, the chair says it's praise. The one thing I want to caution folks is I always, in some respects, I hesitate to talk about those things because I don't want anybody to think that you're doing it wrong. If it's working, that's fine, and then that's the key. You're not, it's not as if in an open meeting law, if you didn't give proper notice, they could void action. That is certainly not the case with following parliamentary procedure.
Break for dinner?
You guys want a 5-minute break? Yeah. 5-minute break.
Yeah.
Okay, we'll reconvene.
Make sure that Joel doesn't take it.
First item on the agenda is the purchase of the Greater Highway Department. John Nines.
No, you missed one.
Well, I move for
Which one?
approval of
Which one?
County
resolution
roads.
2014-41.
I'll second that.
Then pick it up.
We did not.
How many meetings we got going?
Hey, we did that one, didn't we?
We did that one.
We did.
Greater.
Lots
We're
of,
on 41.
41?
Yeah.
Yes.
Yes.
Okay, is Haynes coming back in? Because he'd probably have to be here. Anyway, John Nines, you want to speak to the,
I will repeat what I said, Mr. Chairman. I move for approval of resolution 2014-41.
And Mr. Chairman, I'll repeat what I said. I second that motion.
you guys are talking so much I couldn't hear you. Okay, you want to explain it or is?
Well, as much as we've discussed that already today, I would just like to say that I believe what you see in front of you is what I believe to be the result of the Highway Committee's policy. This is the result of the policy. The money is already there, it's been in the budget. But if anybody wants to know what the particulars of the policy are, I would be glad to give that to them.
Okay.
Okay. Is there any questions? We have to have a roll call vote on that, I suppose.
That one is just a majority.
No? No, okay, just majority. No questions, all in favor say aye. Aye. Opposed? That's passed. Next item is the purchase of a truck chassis, dump body, snow equipment, and highway department. For the highway department. John, you want to?
I'll make a motion to approve this resolution also with the same dittos.
I'll second this one.
Moving along. Is there any questions?
I'm putting ditto.
This is pretty, just what they told us to do. No questions? All in favor say aye.
Aye.
Opposed? That is passed on a 21-0.
You guys ready?
Purchase of a wheeled excavator, the highway department.
Mr. Chairman, I make a motion approval of resolution 2014-43.
I'll second.
Second by Roy. Okay.
There we go.
Is there any questions? Mark?
I'd just like an explanation of exactly what a wheeled excavator is, please.
here it comes.
I'm not against it, I just want to know what it is.
Joel?
It's an excavator with wheels instead of tracks.
I mean, is it a front end loader or a
It's
grader?
an excavator.
Okay,
Backhoe.
Backhoe.
With wheels instead of tracks.
Thank you. That's what I was not clear on.
Big one.
Wheeled excavator.
Rubber wheel? Had to be smart.
No, when you say
Sorry.
backhoe with wheels, then I know what you're talking about.
Backhoe's an excavator.
Yeah.
Is there any other questions? All in favor, say aye.
Aye.
Opposed? That is passed. County snowmobile.
Mr. Chairman,
Yes, sir.
this is a birthday present for the operator, and $170,000 is
Oh, yeah? Okay.
gift.
What does that mean?
I'm kidding.
Explain that, please. Okay. Next item. lost my-
That one went over my head.
You're on 44.
No, wait.
I lost it. Where's it?
Okay, now we get airport parks. 37,
What you mean?
page 37.
Next one is the snowmobile, snow season, snowmobile trail aid. Supervisor Verley, would you like to make a motion and then speak to it?
Thank you, Mr. Chairman. I would make a motion that we approve Resolution 2014-44, County Snowmobile Trail Aid, and it's getting the go-ahead to make application for the aid for maintenance of the snowmobile trail.
I'll second that.
Okay. Do you want to explain a little bit of it, or Eric is back there?
Well, I think the main part is the Anapee Trail. We maintain, and Shirley's already outlined that we spend money up to the amount of the grant and no fiscal impact. So whatever money that we get on the grant, we use to maintain and keep up the county's portion of the snowmobile trail.
Anybody got any questions? If not, all in favor, say aye.
Aye.
Opposed? That has passed. Human Services. Mr. Miller, you're on.
Hang on a second, just helping my fellow supervisor with an issue. Actually, I think this is from Finance Committee, but
I'll do it if you want.
Go ahead.
go ahead, David.
I'd like to make a motion, we approve Resolution 2014-45, Senior Resource Center ADRC transfer of unbudgeted funds.
And I'll second that.
Okay.
The Human Services Committee recommended that the ADRC move to the Senior Resource Center to better serve the community. The Property Committee met and endorsed that after considering it. It was forwarded to Finance Committee to come up with the funding. We're recommending it come out of the contingency expense in the amount of $15,000. It's to cover equipment and furniture that they'll need over at the Senior Resource Center.
Okay, has anybody got any questions? We got Joe back there to answer if we need any answers. Has anybody got any questions? If not, all in favor say aye.
Aye.
Opposed? That's passed. Gifts, grants for the Department of Human Services, Mark Miller. Go ahead and
Okay.
explain, make the motion, please. And
I'll make a motion to approve Resolution 2014-46.
is there a second?
I'll second.
Seconded by Susan. Go ahead and explain it.
Basically, Kimberly A. Shy Skuglik, and I probably ruined the name somewhere along the line, but has made an additional cash gift of $3,000 to the Department of Human Services to help with home issues with seniors, to keep them in their home, such as heating bills or a rent payment or something like that. If you'll remember, she did the same thing last year, and we were very grateful for it, and she decided to match the donation again this year.
Okay, is there any questions?
Line number 27, after the 3,000, what's a proper?
Given.
Okay. Misspelling?
No, that's a real
Is
word.
it pro-offered and
Profit.
it's not spelled right?
It's
Or
a synonym for profit.
Yeah.
For donated.
Proper word.
what is the word?
Proffered. Offered. Proffered or offered.
It should have been pro-offered, or
No, it's a proper word.
there is.
It's an offer.
It's an offer.
My dictionary didn't come up with anything else.
Okay.
Who wrote the resolution?
Leo?
Smarty pants.
No. All in favor, say aye.
Aye.
Opposed? That is passed. Next item is the approval of the Wisconsin Lake Planning Grant for the Dunes Lake Protection Feasibility Study. Mr. Fisher as the chair.
Thank you, Mr. Chairman. I'd like to make a motion to approve resolution number 2014-47. I think the pertinent information is,
Let me get a second first, Ken. Seconded by Randy.
all right, I think if you look on paragraph 4, The Wisconsin Department of Natural Resources has offered a Wisconsin Lake Planning Grant of $3,000. The purpose of said grant is to support a feasibility study to protect Dunes Lake for, I think that word "for" is wrong though, a potential nutrient reduction filtration system using innovative and passive technologies. It's to fund a study on protecting the lake. But I think Bill is back there, but
Yes, he
I have a
is.
question on that word "for." That doesn't sound right in the resolution there. Dunes Lake for a potential, shouldn't that be with a potential nutrient reduction filtration system? All right. But anyway, that's what it's for, Mr. Chairman.
Are there any questions? Mr. Schuster's back there to answer them. So, if not, all in favor say aye.
Aye.
Opposed?
Bill?
That is passed. Zoning fees.
It is right.
That's right. Mr. Fisher again.
Put your
Mariah's
hand
back
out.
there to answer your questions though, so.
Zoning fees.
Wait here now. We missed it.
Just a minute here.
Compensation for certain counties.
Got
Hey, I
it.
missed something on
I would
the
make
agenda, because I don't have the.
No, it's after.
What?
It's after zoning fees.
After zoning fees?
It's number 50.
Page 43.
Oh, I'm sorry.
Go ahead with the zoning fees, Ken.
Yeah, it's a change in some of the zoning fees, obviously. I'll make a motion to approve resolution number 2014-49, but I will make that motion with a caveat that I believe we are going to discuss that at RPC. There are going to be some future changes coming up on the fees.
That's not
Second.
Okay, second to his motion to approve, okay.
Why don't we just lay it over then? If that's what's gonna happen?
I think the correct word is postpone.
Yes, make a motion.
No, because,
Go ahead, Susan.
because we need the shoreland and the conservation fees.
Exactly.
Yeah,
today.
yeah, I just wanted to mention that we will
Okay.
be looking at some more fees. Not many, but there's a couple fees we're going to discuss at some upcoming
But
meetings.
for now,
But for now, this is okay, and you're
For
gonna be
now,
coming
this is
back at a
okay,
later
yes.
date with some different fees on some
Yes,
other subjects.
Yes.
Is there any other questions? All in favor, say aye.
Aye.
Opposed? That is passed. 2014-50 is authorization for a compensation increase for certain county employees submitted by the administrative committee, but I got Kelly coming forward. Would someone like to make a motion to pass that?
I'll make that motion, Mr. Chairman.
I'll
Mr.
second
Wren
it.
and Mr. City. Kelly, you want to explain it? Since you're there, better than me.
Certainly. Last month, I was asked to do a review of the on-call jailer position. I did and conducted the same review as Whipley had done for the positions in the compensation study. There were no true comparables to be found, so I recommend that the 1.66 be approved, and that is also in resolution 2012-65. They are on as a part-time.
Okay. Is there any questions? All in favor, say aye.
Aye.
Opposed? Moving on to the ordinances. A report on the amendment to the zoning map of Nassau Waupee. Mr. Fisher.
I would make,
Boy, you're important today.
there's a lot of them here. I'm going to start it off, but then hand it over to Mariah. Report to the Door County Board of Supervisors amendment to the zoning map of Nassau for Thibodeau Easley. Make a motion that we approve that report.
Okay, is there a second? Seconded by Susan. You want Mariah to speak on it?
Yeah, just explain it quick.
Okay. Mr. Thibodeau and his partner, Ms. Easley, have a property that's partly in county zoning and partly not, and they thought they had correctly marked off the line where the in zoning versus not in zoning was located, but they did not do that, and they actually ended up building like 13 feet of their house and their accessory building into zoning. And this is really the only way to fix that problem, short of having them move the house.
Okay.
And there's not a problem as far as the comprehensive plan is concerned with regard to the zoning district that they're requesting or anything else.
I agree.
Are there any questions? If not, all those in favor say aye.
Aye.
Opposed? That's passed. Now we have to have a motion to have the amendment to the,
Yeah, Mr. Chairman, I'd make a motion, we adopt the zoning ordinance, amendatory zoning ordinance 2014-7.
is there a second? Susan, second? That's going to be a roll call vote.
Yep.
We're going to have a roll call vote.
Supervisor Engel,
Yes.
Fisher,
Yes.
Gunlickson.
Yep.
Haynes,
Yes.
Halsted.
Yes.
Cook,
Yes.
Kohout,
Yes.
Lino.
Yes.
Meyer.
Yes.
Miller,
Aye.
Ninus,
Yes.
O'Connor.
Here.
Runquist,
Yes.
Schultz.
Yes.
City.
Yes.
Burley,
Yes.
Zipper,
Yes.
Osted,
Yes.
Brand,
Yes.
Burr,
Yes.
Engelbert.
Yes.
That is passed 21 yes, 0 no's. Next is the report on the amendment to the zoning map of Liberty Grove. Mr.
Yes.
Fisher.
Yes, Mr. Chairman, I would ask that you accept or approve the zoning map
Report.
report. Thank you. I'm getting mixed up here, so many lines here. And this is to clear up some small parcels of property on, what is it, on Lindum Lane, which is just south of Sister Bay.
Okay, I'll take a second to that.
Second.
Seconded by David Koenig. Go ahead, Mariah.
Okay, as Supervisor Fisher said, this is near Sister Bay, and you can see from the map that's in your packet, it's kind of a tiny little sliver that's between both the village of Ephraim and Sister Bay. That triangular parcel in question is well over 3 acres, but with the zoning district that it's in, it actually can't be split, even though in that district you can have lots that are, I think, 3/4 of an acre. Because of the width requirements, that parcel can't actually be split. So if it gets rezoned to the single-family 20,000, their plan is to divide it into 2 back lots, and then the waterfront portion of the lot is going to be attached to the neighboring lot. So it's really only going to let them create kind of 1 extra lot from what they have.
Are there any questions? If not, all in favor, say aye.
Aye.
Opposed? That's passed. Now a motion to amend it.
Thank you, Mr. Chairman. I make a motion to adopt the amendment to the zoning map of Liberty Grove, 2014-8.
Is there a second? Seconded by Susan. Roll call.
Supervisor Fisher,
Yes.
Gunlickson.
Yes.
Haynes,
Yes.
Halsted.
Yes.
Cook,
Yes.
Kohout.
Yes.
Lino.
Yes.
Meyer.
Yes.
Miller,
Aye.
Ninus,
Yes.
O'Connor.
Yes.
Runquist,
Yes.
Schultz.
Yes.
City,
Yes.
Burley,
Yes.
Zipper,
Aye.
Osted,
Yes.
Brand,
Yes.
Burr,
Yes.
Engelbert,
Yes.
Inigo.
Yes.
That is passed in a vote of 21 yes, 0 no. Next is a report on the amendment to the zoning map of Bailey's Harbor Coal.
And I would ask that you approve the report to the Door County Board of Supervisors for the zoning map of Bailey's Harbor for Mr. Michael Cole.
Is there a second? Susan. Go ahead. Explain.
Mr. Cole has an existing grandfathered non-metallic mine on the property in question, but he also would like to move his trade and contractor business to that site, which is not allowed under the current zoning district, which is natural area. So he requested to be rezoned to countryside. There's not really, the site is so disturbed already in terms of all of the upland is pretty much quarrying area, so I think the committee and staff felt that that it was fine and appropriate in accordance with the county plan.
Mr. Chairman?
Yes.
I just want to inform you, the chair, that I'll be abstaining from voting on this particular issue and the following.
Okay. Are there any questions? If not, all in favor say aye.
Aye.
Opposed? And 1 abstained. Next would be the zoning change.
Again, Mr. Chairman, I make a motion to approve the amendatory zoning ordinance 2014-09 pertaining to the coal property.
Is there a second? Seconded by David. And is there any more questions? If not, roll call.
Supervisor Gunlickson.
Yes.
Haynes.
Yes.
Halsted.
Yes.
Cook.
Yes.
Kohout.
Yes.
Lino.
Abstaining.
Meyer.
Yes.
Miller.
Aye.
Ninus.
Yes.
O'Connor.
Yes.
Rundquist.
Yes.
Schultz.
Yes.
City.
Abstain.
Burley.
Yes.
Zipper.
Yes.
Ofsted.
Yes.
Brand.
Yes.
Burr.
Yes.
Engelbert.
Yes.
Inigo.
Yes.
Fisher.
Yes.
That has passed on 19 yes, 0 no, and 2 abstentions. Got that right?
Yep.
Next is the zoning ordinance text amendments regarding various shoreline zoning provisions, a report.
I'll make a motion to accept that report, Mr. Chairman.
Is there a second?
I'll second.
Seconded by David Leo. You want to explain it, or have Mariah come forward?
Bye.
I could stumble through, as I've said before, but she does it so succinctly, and she does it briefly.
That's
And
the key.
succinctly?
And succinctly, yes.
There's a chart in your packets, I believe, I didn't print out the new packet, so I think for you it's going to be on page 55, that summarizes all the changes.
Yes.
Basically, NR 115 is the state administrative code that lays out the shoreland zoning regulations, and we have until 2016 to bring our entire shoreland zoning provisions into compliance with that new NR 115 code that was adopted a couple of years ago. But in 2011, actually, I guess it was in 2012, but 2011 Wisconsin Act 170 required us to bring into our ordinance now some of the provisions in the new NR 115. So there's a lot of pages here, and I'm not going to walk you through all of it. Basically, what we did was we're creating a new chapter. Historically, the Door County zoning ordinance has had all of our shoreline zoning provisions scattered throughout the ordinance. These changes will put all of those into one new chapter, so we'll have chapter 3A now, which will be all our shoreline zoning provisions. And then in addition to moving everything to chapter 3A, we are putting into effect what the state is requiring that we have in effect now. Grant drafted the first couple of sections, the 3A01 and 3A02. You can see in the packet it tells you which sections have been relocated from other places in the ordinance, so things like the shoreline setback from navigable water, filling and grading in the shoreline areas. Those are all things that are already in our county zoning ordinance. We're just moving them. So the things that are new based on this state law are 3A05, which is going to be on page 61. And that deals with non-conforming uses, non-conforming structures, and substandard lots in the shoreland area. So those are going to be new regulations. Oh, and I should add that we have to adopt these. The state didn't say that these are minimum standards. This is just what everybody has to do. So that section is new. It allows for some things that haven't been allowed previously. There's no longer going to be what we refer to as grandfathering standards in the shoreland areas. We used to have a minimum lot size and width for older lots. Now, as long as you can build on the property and meet all the setbacks, we don't need to worry about what size the lot is, as long as the lot was created legally. There's also, you can do some expansions vertically to structures that you used to not be able to do previously. And then the other main new section in the chapter is 3A08, which is going to be on page 67, and that has to do with mitigation. This was the balance the state decided to strike when they set out these new provisions in the new rewritten administrative code for shoreline regulations. And the idea was we're going to let property owners do things that previously they haven't been allowed to do in the shoreline areas, but they need to quote unquote mitigate the effect on the environment of whatever the project is. So we are now going to have this mitigation section. There's a separate handbook, which has been reviewed and looked at by the Resource Planning Committee and approved. Grants looked at it, the DNR has looked at it, and that will give property owners an idea of their various options that are out there to quote unquote mitigate their project. So it could be something like putting in a rain garden or making sure that they don't cut down the vegetation along the shoreline or those kinds of things. So those are the only two sections that are new in the chapter.
Is there any questions?
There you go.
Charles?
Yeah, I guess, I mean, not having time to look at all the different changes here, but it says 75 feet from the high water mark on an old lot that was developed, I don't know, 40, 50 years ago. If your lot line from the highway and your high water mark go like this. Is that
Then you
still-
need to get a variance.
It's still a variance?
Yeah. Yeah, and that section, the water setback section, that's exactly the way it is in our ordinance now. It's just getting moved to there. And we actually are looking, the DNR does allow, and Door County has never done this, but I think we'll talk about it when we update the ordinance completely to the new NR 115 standards, where in those cases where there's an overlap, or, where they meet the two setbacks, that maybe we could put a provision in the ordinance that we would relax the road setback without a variance. So that's something we'll probably be talking about.
Can I ask a question?
Sure, John.
Does it, like a fire pit, like we've had issue in our area, is there anything changed on that?
Nope, the state law is still the same.
So that 35 feet from the high water mark, a structure is not considered a fire pit, or?
No, that the state law hasn't changed in that regard. A patio is, if you're sticking a metal ring in the ground, or you're buying like one of those Target fire pits that you can drag around your yard, that's fine. If you're going to start laying patio stones out around it, then it turns into a structure under the state's definition.
Okay, so there is a structure is so many square feet apparently, right?
Well, there's not really a square foot minimum. Is there a particular section that you're looking at right now?
Yeah, I just lost it. Square footage of the footprint of all structures located in shore, 200 square feet, okay.
Oh, I think I know what you're looking at. There's a provision in the state law that you can have, well, it's called the gazebo law, or the John Guard law, that you can have something that's smaller than a certain square footage within the setback area between 35 feet from the ordinary high water mark and 75 feet, as long as you do all sorts of other things, like basically revegetate your shoreline. So if someone wanted to revegetate their shoreline, then they could have a structure that was under that square footage in the setback area. Most people don't want to do that. They don't.
Well, you know what I'm talking about, the situation we had.
Yep,
That was
she could have- she could have-
offered to her, she had the
Correct.
chance to do that?
She
Okay.
could have done that.
Are there any other questions? If not, all in favor, say aye.
Aye.
Opposed? That is passed. Now, motion to do the zoning ordinance change.
Yes, Mr. Chairman, I make a motion to approve the mandatory zoning ordinance 2014-10.
There's seconded by Don City. Is there any more questions? Roll call. Almost forgot.
Supervisor Haynes,
Yes.
Halsted,
Yes.
Cook,
Yes.
Kohout,
Yes.
Lino,
Yes.
Myers excused, Miller,
Aye.
Ninus,
Yes.
O'Connor,
Yes.
Rundquist is excused, Schultz,
Yes.
City,
Yes.
Verley,
Yep.
Zipper,
Aye.
Osted,
Yes.
Brand,
Yes.
Burr,
Yes.
Engelbert,
Yes.
Inigo,
Yes.
Fisher,
Yes.
Gunlickson.
Yes.
That is passed
Two excused.
to excuse unanimously, otherwise, of the people here. Next item on the business is election of Civil Service Commission. This is to replace the John Cook, correct, John?
That is correct, Mr. Chairman.
You had to resign because of your,
I resigned my position as Civil Service Commissioner due to my appointment to the county board.
Grant, does this just take a motion to do it, or do you have to have just a formal nomination? Is that what we need?
You need to confirm Maureen's appointment, so it could be done by.
This is an election.
Oh, this is election, oh,
Okay.
sorry, I was reading. Yeah, the election would be simple, like we do
The
any
regular
other
election?
elections, and you
Would
can do it by,
someone like,
again, you've got one candidate.
Correct. Someone like to nominate
Mr.
James
Chairman,
Grondin?
I would like to nominate James Grondin for the election position of the Civil Service Commissioner. That was vacated by myself.
Okay. I don't know, that doesn't really require a second. but
You're right.
Is there any other nominations?
I would make a motion to close the nominations and cast unanimous ballot for Mr. Grand.
I'll second that.
Thank you. All in favor, say aye.
Aye.
Opposed? That happened. Okay. In your packet is the budget schedule for 2015. I just remembered I'd like to make a very short comment. If anybody wants to make some adjustments to the county budget, now is the time to start to make those adjustments. Don't come, what is it, our last date, November 30th or November 12th at the county board member and try to make some adjustments. If you want to make some adjustments to the county budget, now's the time to go before your committees and start to make those adjustments. And it makes it a lot more comfortable when we go into the final couple days of the budget that all the arguments and discussions that are taken care of. So just keep that in mind. It's a schedule that last number of years, 4, 5, 6 years, have worked very, very well. And when it came to budget time, It was very, all the arguments were settled during the next 5 or 6 months, whatever it is, so I think it works very good that way. Done.
Yeah, Mr. Chairman, it's my understanding then that the county board November meeting is just one meeting, and that's November 12th?
It's always scheduled for 12th, 13th, and 14th or thereabouts. In the last number of years, it's just lasted one day, but we keep it open in case we start to get into some discussions on the budget. Years and years ago, when you were here, sometimes it went 1, 2, 3 days because we went over it line item by line item by line item. Now we try to get that all done at committee levels and department head levels and administrative levels and try to get all the pros and cons solved before we get to that day.
Again, clarification then is there is no meeting on the fourth Tuesday.
As of now, yes.
Okay, thank you.
But that doesn't mean there might not be, though. There might be something that comes up. That's a long ways off. I can't, you know, but right now it's scheduled for the 12th day in November. And I can't, what, probably?
I think you're
Yeah. Okay.
Thank
Right
you.
now it's the 12th of November.
Thank you, Mr. Chairman.
Are there any oral committee reports? Anybody have any questions on the minutes? Review of the vouchers, claims, and bills? And the WCA conference is in Wisconsin Dells, September 14th and 16th. Do you have everybody either committed or not committed, or?
Nope, you would have received your registration information in the mail. There's a form in there you should fill out and return to me if you want to go.
There are room reservations made. So. Go ahead.
Are there any block of rooms right at the resort for those going?
Yes.
At the Kalahari, aren't they? Right. Better luck. Okay.
Why, when does she have to know?
Whether you're going or not.
By when?
By when?
The sooner the better.
Yesterday.
If I tell you a deadline, you'll wait till the end.
So the deadline is tomorrow.
4 o'clock this afternoon?
Right.
Mr. City.
Mr. Chairman, before we adjourn, I just would like to thank Supervisor Fisher and Supervisor Enigo for bringing the Wisconsin Counties Association.
That was Supervisor Engelberg.
That's what I said, right?
No, you said Enigo. Don't give him that.
She's pretty adamant about
The
it.
senior, it's what they call a senior moment.
To the meeting today. Thank you.
Okay.
You're right.
Motion to adjourn?
I'll make that motion.
Second. June.
All in favor, say aye.
Aye.
Got it?
Yeah. You said Enigo.
Said Enigo.